Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in this video we will be covering nuisance. Nuisance will be covered in two parts. Part 1 will be public and private nuisance and part 2 will be the defenses available for nuisance. Now, nuisance as a tort means an unlawful interference with a person's use or enjoyment of land or some right or in connection with it. Now, any act that interferes with comfort, health or safety of the occupants of a property are examples of nuisance. The interference may be any way: noise, vibrations, heat, smoke, water, gas, etc. Now, there is a difference between trespass to land and nuisance. On the basis of type of interference, trespass is direct and nuisance is consequential. For example, planting a tree in someone's land is trespass, but if the tree planted in one land protrudes onto someone else's land, it will be termed nuisance. Throwing stones directly will be trespass, but if the stones fall from a ruined chimney, then it will be nuisance. On the basis of possession of land, trespass is an interference with the direct possession of land, whereas nuisance is interference of a person's enjoyment with that land. Trespass is always committed through some material or tangible object. Nuisance can be committed through the medium of intangible objects like smoke, sound, etc. Trespass is actionable per se, but for nuisance, special damage has to be proved. Now, public nuisance. Public nuisance is a crime as it is the interference with the right of public in general and is punishable as an offence. This comes under criminal law and is done so as to avoid multiplicity of suits because many people will bring in civil suits under civil law. In certain cases, when any person suffers from some special or particular damage different from what is inflicted upon public as a whole, a civil right of action is available to the person injured. For example, digging trench on a public highway may cause inconvenience to the public at large. No member of the public can bring a case against the defendant, but if any one of them suffers more damage than suffered by the public at large, for example, a person falls into the trench that is dug, he can sue in tort. In order to sustain a civil action in respect of a public nuisance, there is supposed to be a proof of special and particular damage. In the case of Rose versus Mills, the defendant had wrongfully obstructed a public navigable creek and the plaintiff had to incur extra costs to transport his goods via land. In this, a civil suit was brought against the defendant in respect of a public nuisance and proof of special damage was that the plaintiff had to incur extra costs. Now, private nuisance or tort of nuisance. In this, there are three essentials for a wrong to be a tort of nuisance: unreasonable interference, interference with the use of enjoyment of land, and damage. Unreasonable interference. Interference may cause damage to the plaintiff's property or may cause personal discomfort to the plaintiff in the enjoyment of property. To constitute nuisance, the interference should be unreasonable. Every person must put up with some noise, some vibrations, some smell, etc., so that members of the society can enjoy their own rights. An act which is otherwise reasonable does not become unreasonable and actionable when the damage, even though substantial, is caused solely due to sensitiveness of the plaintiff or the use to which he puts his property. If certain kind of traffic is no nuisance for a healthy man, it will not entitle a sick man to bring an action if he suffers. Second, interference with the use of enjoyment of land. Either there is an injury to the property itself or injury to comfort or health of occupants of property. Now, third essential is damage. Unlike trespass, which is actionable per se, actual damage is required to be proved in an action for nuisance. In the case of public nuisance, the plaintiff can bring an action in tort only when he proves a special damage to him. In private nuisance, although damage is one of the essentials, the law will often presume it. In the famous case of Fay versus Prentice, a cornice of the defendant's house projected over the plaintiff's garden. It was held that the mere fact that the cornice, that is the rainwater pipe, which projected over the plaintiff's garden, raises a presumption in the court that the fall of rainwater onto the plaintiff's garden will damage, and the same need not be proved in court. It was held as nuisance. Thank you for watching this video, and I hope it was informative.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.